Good afternoon and good morning to everyone, wherever you may be, and welcome to our webinar today. The presentation is sponsored by Keesis Health and QIP Solutions, and we're happy to bring you this webinar on meaningful use, fraud enforcement, and audits with Rich Sanders of the Sanders Law Firm. I am Adam Bullion. I will be your moderator, excuse me. And by way of housekeeping, we're going to hold all questions until the end of the presentation, which we will reserve time for questions. You can ask a question either by raising your hand, which is a function under the mute button you should see. I will then unmute you and you can address our question to the presenter. Alternatively, you can use the chat function to type in a question, and then at the appropriate time, I will address that to Rich. As I mentioned, we are privileged to have Rich Sanders as our presenter today. He is the president with the Sanders Law Firm in their Atlanta office. He represents a variety of healthcare clients on a number of issues, including business transactions, certificate of need issues, staff credentialing, Medicare reimbursement, legislative and regulatory activities, as well as fraud and abuse compliance. He holds a bachelor's degree from Duke University and is a graduate of the Emory University School of Law. Rich, I appreciate you being with us today, and I will turn the presentation over to you now. Thank you.
Thank you, Adam. And good morning and good afternoon to everybody. I want to thank you, Adam, for your introduction, and thank Mark Pretner for inviting me to present to y'all this morning on this important topic of legal compliance. We're going to be discussing over the course of our time together today the increasing trend towards fraud enforcement by the federal government in meaningful use fraud. Talking about what that means, going through a specific case that is pending currently in federal court, and then discussing implications for physician practices and other providers that may have received meaningful use funds through that federal program. As Adam mentioned, there will be plenty of time at the end of our webinar for questions, so please come to the end, but we'll make sure that we set it up so that everybody gets a chance to ask their question to the extent possible. Any further ado, let's get rolling through our slides here. This first slide, number 2, is a description of what meaningful use means, just as a summary, because many of you, I understand just by nature of having either dealt with Keesis or with QIP, are familiar with the Meaningful Use program, and many of you may have received funds from either Phase 1 or now Phase 2, so we just need to cover this very briefly. But Meaningful Use basically is a federal program started by Congress in passing the law, the American Recovery and Reinvestment Act of 2009, that was then implemented by CMS to encourage Medicare providers and Medicaid providers to adopt and meaningfully use certified electronic health record technology. As you see here in the laundry list of bullet points, that means that there are a number of different steps that providers have to take in order to certify to the government that they are meaningfully using electronic health records. And as a result, upon that certification, CMS sends a certain amount of funds to a provider, depending on various circumstances, in exchange for that adoption and meaningful use of those electronic health records. This is a new regulatory system within the last 3 years that many of y'all are likely familiar with. So we'll move on to the next slide. The specific objectives for eligible professionals are administered by CMS, the Center for Medicare and Medicaid Services, and specifically operated by the Office for Incentive Programs. But as you have probably heard, either from dealing with Mark and Susan or Adam separately, there's a lot of overlap between this meaningful use program that all comes under the Department of Health and Human Services, and the HIPAA privacy and security rules, which are administered by a separate office. So one of the things we'll talk about today as we go through our discussion of meaningful use and meaningful use fraud is the implications of that regulatory scheme for the regulatory scheme set up by the Department of Health and Human Services under HIPAA in the privacy and security realm, and that's administered by the Office for Civil Rights. These two regulatory, arrangements are overlapping, but not always consistent, and certainly pose an equal set of, distinct set of responsibilities with equal potential burden to a physician practice or other kind of eligible professional. So we'll move on now to slide 4. The various stages of meaningful use mean that a couple of things. The first is that we're already now, as many of y'all can attest, we're already now well advanced in the adoption and meaningful use of electronic health records in the healthcare industry in the United States. I would say, speaking for our clients' purposes, where we represent hundreds of physician practices across the United States and a number of hospitals, the majority of those practices have adopted and meaningfully used electronic health records. I don't have a specific statistic through the end of 2013, which would have been the most recent reporting year, but my understanding is even though the majority of our firm's clients have adopted and meaningfully used EHR, that the majority nationwide have not. So there's still a long way to go for our healthcare system to get compliant with these rules and start meaningfully using electronic health records. And as in anticipation of that, the government has set up stages that will evolve over a 5-year period. As you see here, stage 2 is this year. There's a lot of folks who are wrestling with compliance with stage 2. And then, of course, stage 3 comes in another couple of years. Ultimately, the trend that's established here, both under the stimulus bill from 2009 and the health reform law from 2010, is that Medicare and Medicaid, to a lesser extent, are really going to focus increasingly not just on electronic health records, but on improving outcomes for Medicare and Medicaid enrollees and tying compensation to those improved outcomes. So that's kind of the big picture trend that we see in government reimbursement for healthcare services. The context of that is in a big push by the federal government to get folks to adopt and meaningfully use electronic health records. Now, of course, the problem with that is that whenever a regulatory scheme is set up to incentivize folks through payment, there is the opportunity for fraud. This is not anything new. In fact, the False Claims Act, which is the primary law that the government uses to either pursue civilly or prosecute criminally folks for defrauding the government, the False Claims Act was passed by Congress right after the Civil War. And so as long as Americans have been doing business with the federal government, Americans have been trying to defraud the federal government. Today's discussion about meaningful use fraud then comes on the heels of 150 years or so of the federal government doing its best to protect taxpayer dollars from improper spending. So along that line, one of the foundations of the meaningful use program is regular audits performed by CMS. Any provider who receives an electronic health record incentive payment under the meaningful use program may be subject to an audit. And having said that, we'll talk in a little bit about what that means and how best prepare for those audits. It's just important to know conceptually that, hey, being a part of this meaningful use program and receiving those funds means you're putting yourself on the radar and subject to a potential audit. Providers can be audited up to 6 years following the date of attestation. So if your practice is an early adopter of electronic health records and meaningfully using them from an early stage, well, then you're already halfway through that potential audit period if you had tested back in 2011. Our recommendation, as you see here, and we'll talk in more detail about this later, our recommendation is to have audit-ready files, we'll discuss what that means, available each year that you make any kind of attestation under the Meaningful Use program. As I mentioned, the False Claims Act has been the primary, we're on slide 6 now. The False Claims Act has been the primary tool that the federal government has used to prosecute and in a criminal setting and pursue liability in a civil setting against individuals or companies doing business with it for nearly 150 years. Because anti-fraud measures are so popular, Congress on a regular basis revisits the False Claims Act and increases the penalties that are available to the Department of Justice for fraud against the government that violate the False Claims Act. Now you see here on our slide 6 that the potential violation of the False Claims Act brings with it very stiff penalties. Notice here in this first bullet point, there's a lot to kind of digest. The first is that based on the Department of Justice's discretion, a penalty between $5,500 and $11,000 per claim. Then you see prior to that in that bullet point, the phrase treble damages. Based on the government's assessment of how bad the provider's conduct was or how potentially egregious, I guess would be the fancy legal phrase, meaning basically, did you really mean to do it and was this a concerted effort to defraud the government? Well, then the Department of Justice can triple the amount that's due. That's how, this is not a legal phrase, this is just a Rich Sanders phrase, but that's how you get to monopoly money dollars. When you're talking about when you're talking about a provider that has a heavy load of Medicare patients and is sending in a couple of hundred claims per day, whether it's for office visits or imaging or lab or what have you, and do that for a couple of years, and then multiply that by $10,000 and then triple that, I mean, you get to a lot of zeros. And notice in that second bullet point, the standard that the Department of Justice uses is knowingly submitted a false claim. The position of the government for years has been that the phrase there, which I reckon is an adverb, knowingly, applies to submitted, not knowing that it was false. So in other words, if you submit a claim and you know that you submitted a claim, if it turns out to be false, you violated the False Claims Act based on the traditional application of that definition by the government. Now, of course, defense lawyers like me look at that and say, no, knowingly is an adverb that applies to the adjective false. So you have to know that it's false at the time you submitted it in order for the False Claims Act to be violated. And of course, lawyers spend a lot of time across the United States every day arguing about just that phrase. Why is that important in this context? Well, as we're going to get to talk about in a second, when you, as a practice, attest to having met expectations of the Meaningful Use program and having done certain things in your practice to justify receiving the incentive payment from the feds, the question at the time you attest from the government's perspective is not whether you knew that attestation was false at the time, it's whether you knew you were attesting at the time. If it turns out to be a false attestation, they're going to try and come after you under the False Claims Act anyway. I should also say, just as part of this False Claims Act, because it's a really important educational moment, is that under the PACA, the health reform law from 2010, the False Claims Act was amended to require whenever a Medicare or Medicaid provider becomes aware of an overpayment, that overpayment has to be repaid to Medicare or Medicaid within 60 days of identifying that overpayment. That's just a kind of a note that ties into the False Claims Act, but is still recent enough that we try and remind folks on a regular basis. Let's move on to slide 7. There's one case that we're aware of pending currently in federal court that involves meaningful use fraud. We anticipate, though, based on our conversations with United States attorneys across the country, from having heard presentations both from the Department of Justice in Washington and from U.S. attorneys around the country, this is going to be a big deal. That coming after providers who have made false statements to the government so that they could get meaningful use payments is going to be an increasing area of fraud enforcement from the federal government. And so this first case in Texas is kind of the bell cow. This is out in the Eastern District of Texas and was a case brought by the federal government against this gentleman, Joe White, back in February of this year. Let me say, first of all, especially anybody who's from Texas or knows Joe White, these are allegations, and he has pled not guilty. And so I want to be careful at the outset to let everybody know that this is a pending case in which Mr. White vigorously defending his innocence, his lack of liability, but one which the government is nonetheless prosecuting. So Mr. White worked out in a hospital called Shelby Regional, and back in 2011 hired on behalf of the hospital a electronic health records vendor to come in and help the hospital with its EHR program and adopt and meaningfully use that EHR. One of the reasons was so that the hospital could get the meaningful use incentive payments. Moving on to slide 8. In October of 2012, the government alleges Mr. White created a user ID on the EHR website, or I guess the EHR software, that then matched the username and ID that he created on the CMS website for meaningful use attestation. He did so, allegedly, creating a user ID that tied to the director of nursing's information. So using her name, address, and other personal information to create that account on the CMS website for meaningful use attestation. It's unclear why he would have taken that extra step based on the allegations that I've read. And presumably, Mr. White is contesting this and saying that it didn't happen, since he has entered a plea of not guilty. At that time, Mr. White allegedly asked the director of nursing to submit the attestation in 2012, saying basically that the Shelby Medical Center had adopted and was meaningfully using the electronic health records then in place. The director of nursing at that time then refused. So the allegation from the government goes that at that time he created this account with her name and information and submitted the attestation on behalf of the hospital, and did so without her approval, without her knowledge, and basically kind of on the sly. So having said that, what's the problem there? Let's just stop there and say, okay, the government's alleging this, so why is that a biggie? Well, it really comes down to two things. One is that he submitted the attestation on behalf of the hospital, and it's unclear whether the hospital had complied. We'll see in a second. The government is alleging that it had not. And two, he's filing an attestation with the federal government with information that he used without approval and someone else's individual information without approval. I will tell you, we talk about intersections of privacy and fraud. One area we see a lot now in our practice, which does handle these kinds of compliance issues and white-collar criminal defense like this, is it's becoming increasingly a trend for folks to steal other people's information so that they can then file fraudulent tax returns to the IRS and receive a refund. We've dealt with two cases just in the last 12 months where our client, Physician Practice, has had one or more employees steal patient information, file tax returns with the IRS that are fraudulent, get refunds, and then try and basically get away with the stolen money. And in both cases, they're being criminally prosecuted. So this area of misuse of information and fraud is a very hot one for the federal government right now. As you'll see on the next page, that's because it leads to big dollars. As a result of Mr. White's attestation to the CMS regarding meaningful use adoption there at Shelby received $786,000 in incentives for meaningful use compliance. The government maintains, though, that Shelby did not meaningfully use electronic health records, but instead used paper records the whole time. Isn't that something? So the government alleges that even though Mr. White, using the nurse's ID to set up a fake ID, basically, with the CMS website, even though he was attesting that the hospital had adopted and was meaningfully using EHR, it sounds like the government's maintaining that it was paper the whole time. And when it wasn't paper, Mr. White instructed the EHR vendor to manually input data into the system after discharge. So imagine that. At least what the government's alleging is a patient would get admitted to the hospital, cared for in the hospital, then discharged. Mr. White would carry the paper chart to the EHR vendor and say, okay, put this all into the computer. That's what the government's alleging. That is difficult to imagine how that would work operationally, but that is the nature of the complaint. On slide 10, we'll go through the two counts. The first one, of course, is a false statement, and this ties into the False Claims Act ultimately, that Mr. White allegedly submitted EHR attestation in 2012, certifying that Shelby met the meaningful use requirements, and as a result was paid improperly $786,000. And of course, as we mentioned, in that certification, Mr. White certified as if he was the director of nursing. Slide shows count 2, which is aggravated identity theft. This is a different kind of federal crime in which a person who uses another person's name and personal information, including, notice here, the Social Security number, during the commission of a felony, commits a separate felony. So identity theft is a crime on its own. Aggravated identity theft becomes a different issue when you're committing identity theft to go then commit a separate crime. The government alleges that that this activity took place at other hospitals, not just Shelby, but we were not able to provide any additional details on that. Let's move on to slide 12 then. So here's the scope of the issue, and one of the reasons I imagine that Adam and Mark and Susan from QIP and from KESIS, respectively, wanted us to talk about this today. The scope of the issue, both for healthcare providers and participants in our industry, and for all of us as citizens and taxpayers, is really massive. Eligible hospitals so far under the Meaningful Use program have been paid just over $14.5 billion. Eligible professionals have been paid just over $9 billion in the last 3 years. So the scope of the program is truly monumental in terms of dollars being paid out in a very short period of time. The reason that's so important is not just for you to understand how big the Meaningful Use program is, but just to understand that the government's view on this is, with this massive amount of money being paid out to Medicare and Medicaid enrollees or enrolled providers, that it's got to make sure that those payments were deserved. And that when folks are attesting, yep, I'm ready to comply with the Meaningful Use standard, that is because it's got a lot of money on the line, reliant on the fact that folks actually did what they said they were doing. So with that in mind, then, let's stop here on this slide and talk for just a second, because we're coming up on our half hour. Talk for a second about what's the best way to prepare for CMS conducting an audit of your meaningful use compliance. I would say go back to that slide. The first order of business is making sure that with each of the years that your practice or your organization has attested meaningful use, that you maintain the documents that you had in your possession at the time to support your compliance at the time. So in other words, if your 2011 meaningful attestation provider, you want to make sure that you have a file, doesn't really matter, but you have a file that says, okay, here's how things looked in 2011. Here's what we knew at the time that we made our attestation. I would encourage you to compile that now just so you have it ready for audit if necessary. For those of you who are wondering, well, were we compliant at the time? That's probably a good question to discuss internally. And then as you think about investigating whether and how much you had taken steps to comply at the time, that you do so with the advice of a lawyer. Because it is important whenever you go taking an internal audit or doing an internal investigation, to the extent possible, that you use an attorney to help protect the results of that audit or investigation under the attorney-client privilege. That's something that we recommend whenever our clients do an internal audit or investigation, that they get us involved at a high level and without participating in the audit itself unless they want, but get us involved to try and protect the audit results from out of disclosure and thus get confidential under the attorney-client privilege. Mark, let me ask you to chime in and see what your thoughts are about the best way to prepare for a meaningful use audit.
Sure, Rich. Thanks so much for the wealth of information. And just from a preparation standpoint, I think you go back to that term knowingly. From an audit perspective, when you talk about even privacy and security being intertwined into this, you have that term willful neglect that I'm sure everybody has heard about, or neglect. So when you talk about meaningful use and being prepared as an organization, your privacy and security turns into, from a HIPAA perspective, your actual risk management program. So it goes well beyond just the requirement of a risk assessment and moves into, okay, from my assessment, how do I analyze that? How do I remediate? What is my ongoing living, breathing program that I can then present to the auditor? That is what we are seeing. That is the verbiage and stance we are seeing from auditors during your attestation period. They are looking for active documents, living documents. So, I mean, that's kind of a key here. I think being audit ready, your only real stance at audit ready is a program that you manage from on a consistent or active basis. And your ability to present that back to the auditor, whether that's a desk audit or if they truly come to your place, that will save your organization time and money from investing in that. So it's really just kind of reiterating the point and the fact that you see the dollars on the screen here. It's really not a matter of if, it's just a matter of when and the consistency of this because of the dollars out there. And it's just that there's so many components tied into it. So it's just really good to have your finger on the pulse of the entire attestation process, all the pieces and parts that go into it, and privacy and security being one of those big pieces.
That's a great point, Mark. And one of the areas that I had in mind earlier when I mentioned that privacy and security overlap with meaningful use requirements, that risk assessment is a really critical aspect of this because the government wants to make sure on the meaningful use side that if you are receiving funds from it for adoption and meaningful use of EHR, that hardware, software, and patient information is all going to be protected as we near the end of our time together.
Yes, absolutely. Thank you, Rich, and thank you, Mark. I do have some questions, but first for the attendees, I didn't properly introduce Mark at the beginning. He is Vice President of Keesis Health, which is one of our presenters today in Birmingham, Alabama. And Mark is a healthcare consultant, does a lot of work with HIPAA and meaningful use. But Rich, I did have several questions. One is in the case that you discussed with Shelby and Mr. White, was that a situation that was discovered and prosecuted from a meaningful use audit, or maybe a whistleblower? Are you familiar with how that case rose to prosecution?
I am not familiar how the case rose to prosecution, other than I can say I did not see any mention of a whistleblower claim or any kind of relator being mentioned in the press releases or various articles that I've seen on the subject. So in my experience, we could probably deduce from that this was a government-initiated complaint.
Okay. Another question I have from one of our participants is, what should somebody do if they realize they attested to something, but they were actually not in compliance with that? What is sort of the first course of action? How do you throw yourself on the sword?
So if you are in that situation and realize that you have possibly attested to the meaningful use standards but haven't been either compliant at all or fully compliant, I would encourage you, number one, not to say so on this webinar since this is being recorded. Two, to contact a healthcare attorney with expertise in this area. There are a couple of options for how to handle that situation. Mark mentioned an important word, remediate, and it'll just depend on how much of the meaningful use standards have not been complied with and in what way for the provider to figure out how to remediate. And one of the reasons we mentioned that requirement about repayment of overpayments is if that level of noncompliance with attestation is I guess meaningful, is material, then you might likely be in a repayment situation. Again, that's an area where you would want to get advice from a healthcare lawyer with experience in this area, because you may find that that repayment is necessary, may not be. If it is, there's a certain process to go through. So that's a great question. Unfortunately, a loaded one.
Certainly. So another question, and you touched on the security risk assessment, which is required within the Meaningful Use, and it's also required within the HIPAA security and privacy rules. And folks may be hearing also a lot of saber rattling about the round of HIPAA audits, which are going to be coming up, and OCR, which will be conducting those audits, is talking a lot about do a security risk assessment. Rich, to your knowledge, is there anything that precludes a security risk assessment done by an organization to serve the meaningful use requirements as well as the HIPAA security requirements? Can they be used for both?
You know, that's a great question, Adam. The way you phrased it, is there anything that precludes the risk assessment being used for both purposes? No, not that I'm aware of. And in fact, I think the flip side of the coin is also true. I would encourage folks to do a risk assessment. One, because it's really important to gauge the risk to your electronic health record system, period. But it is also a requirement of the HIPAA privacy and security rules, in particular the HIPAA security rule, and a requirement of the Meaningful Use Program. Look, and here's the thing. I see we've had a number of callers in today from area code 205, and I saw at least one from 251, which is South Alabama. You know, especially this time of year, I've always got hurricanes on the mind. We've done a lot of work with physician practice in Mobile and the Gulf Coast areas over the years, and it's easy to think back to how damaging and destructive Hurricane Katrina and the other big storms during that time have been. In those days, having a flood related to a hurricane would get all your paper records wet and ruin a lot of documents, including those that are in storage. Now, in electronic world, it's so much easier to try and preserve and properly store those records electronically and off-site. Doing a risk assessment is really a critical part of practice operations, not to mention required under both of these rules. So yeah, I think to the extent that you need to tailor a risk assessment to one or the other, you can certainly do that, but one, it can be a part of a total effort. Mark, do you have any thoughts on that?
No, I think just dovetailing that, I mean, that is the other part. That's kind of step one, is starting the assessment process. And then knowing that they're going to actively look for, once you identify through your assessment your gaps, and we all got them. That's just the nature of business. Then it's how your business then operationally starts to handle remediating those gaps, and it's a great business operations practice. That's really what the intent, I think, of the whole law and why they put penalties into it with the High Tech Act. They were realizing if we're going to push everybody towards an electronic interchange, an electronic exchange of all this information, then the exposure goes up. So in the ability and technology changing so fast, you can't handle risk in a project mode anymore because it changes so fast. So the ability of what is my work plan and how do I close those gaps? What are my procedures? What are my policies? Even greater, how am I training on it? Am I training my employees? Am I keeping track of that? And that's really what HIPAA was designed to do and had been under the covers for so long, but quite honestly, the need wasn't there because we were still doing a lot of paper. You didn't have a lot of effect from an electronic perspective or an exposure to people's information. But now with the data that is available and the data leakage potential that comes to you in your exposure rates, it's just critical to have that process kick off, and then, but even more critical to understand as your organization, how am I going to manage from my assessment and once it's created, because that is key to what any audit will come at you. Not only will they be looking for your assessment, they're going to be looking for the documentation on your remediation efforts. Things is very specific, like your list of BAs. They're going to want that in a report. There are just some very specific things that they're after, and those, that just steps in the process, if you will.
Great. We've sort of bled over our time here. We have, so if anything, I think our presenters can hang on for a few minutes of opinion to our attendees. These guys really know what they're talking about, whether it's meaningful use or HIPAA or anything and similarly situated in the healthcare space. They know what they're talking about. If you happen to be in the southeast section of our country, they're great resources. So really, gentlemen, thank you very much. Rich, very much appreciated. For the attendees, we will send out a copy of the slides as well as the recording. It takes a little while to process, so it may be tomorrow morning before I can get that out to everybody. And I will include Rich, Mark, and my own contact information if you have any follow-up questions. We will have another webinar. We haven't decided on our topic. It'll probably be in about 3 weeks. As you know, we usually have them on Wednesdays at about the same time. So look for correspondence in the coming days once we finalize our topic for that. So I haven't received any other questions. I will end the presentation here with a big thank you to Rich. Thanks for Mark for your input as well. And thank you to everyone for participating. I think it was great content and a very, very good presentation for everybody. Thank you all.
Thanks so much, Adam.
Thank you, Rich.
Thanks.